Public Protector Advocate Busisiwe Mkhwebane is about to release investigation reports in her virtual media briefing. Let's go live to that.
We made adverse findings of maladministration and improper conduct and took appropriate remedial action. In taking appropriate remedial action, we sought to take the complainants as close as possible to where they would have been had it not been for the improper conduct and maladministration. We also sought to correct the system as to prevent the recurrence of the maladministration which has taken place, and we also aim to then stem out impunity which, if not acted upon, can serve as a breeding ground for this very improper conduct, maladministration, and prejudicial conduct. We are pleased with our modest impact thus far. In most of these, of the 86 reports we have issued up to this point, organs of state have responded positively. In some instances, they acknowledged their wrongs halfway through investigations and undertook to make amends right then and there. Such undertakings were expressed in response to Section 7(9) notices, which we serve on those against whom we contemplate adverse findings in terms of the Public Protector Act, the aim being to grant them an opportunity to make representations against the intended findings and remedial action. I will cite but only a few examples which we have done the above. So the one relate to service delivery case, and the other the conduct failure matter. The thorough work we did alongside other sister Chapter 9 institutions like the South African Human Rights Commission to restore the dignity of the people of Alexandra who have for years lived in deplorable conditions is one such example. And the city of Johannesburg owned up to its service delivery failures in that township and committed to do right by that community. We are monitoring progress in that regard. On the conduct failure front, ministerial advisors at the National Department of Transport who were not only improperly appointed but paid at a higher scale than they were entitled to continue to pay back the excess amounts to the public purse after both the Minister and the Director General in that department acknowledged the maladministration and undertook to make amends. Of course, there are a few other cases that have been taken on judicial review with the aggrieved parties exercising their rights as they are entitled to. We are opposing some of those, and where it serves no purpose to oppose, we have opted to abide by the court's decision. A number of other investigations and interventions are underway. These include the work we are doing in ensuring that tertiary students are in the lecture hall at the beginning of the academic year, as opposed to engaging in violent protests, fending off financial exclusion, and other hindrances. We are also finalizing the systemic investigation into the challenges facing the public, particularly women and children, in the South African justice system. This is specific to issues of gender-based violence and femicide and child maintenance. We launched this investigation at the beginning of the financial year, and we have made considerable progress. We hope to release the findings soon. Today, we end the year 2021 with 9 investigation reports which deal with a range of issues, from everyday struggles that the public contend with to complex issues of public procurement and executive ethics. Let us start with the issues relating to prejudicial conduct. I'll hand over to the Deputy Public Protector to take us through those reports.
Thank you, Public Protector. Very good afternoon to yourself, Chief Executive Officer, Acting Chief Operations Officer, Executive Managers, the Chief of Staff, members of the media, the public at large, ladies and gentlemen. And under the prejudicial conduct, I will start with the matter of Siapamuri versus the Salt Lake municipality in the Northern Cape. We investigated allegations of improper conduct and maladministration relating to wrongful burial of the late Mr. Beshu Joseph Khumalo in the grave of the late Mr. Joseph Mkhwebane by the Salt Lake municipality in the Northern Cape in 2013. This followed a complaint lodged in September 2019 by Ms. Kihelwe Siapamuri, Ms. Mkhwebane's daughter, Mr. Mkhwebane's daughter rather. Ms. Siapamuri alleged that in 2013 the municipality buried Mr. Khumalo in the grave of her father, Mr. Mkhwebane, who had been buried at ABC Cemetery 36 years earlier in September 1977. Essentially, Ms. Siapamuri alleged that the wrongful burial by the municipality was improper, constitutes maladministration, and prejudiced her family. We focused the investigation on whether the municipality buried Mr. Khumalo in the grave of Mr. Mkhwebane, and if so, whether the conduct of the municipality was improper, constitutes maladministration, and prejudiced Ms. Siapamuri's family. We found that the municipality did indeed bury Mr. Khumalo in the grave of Mr. Mkhwebane in 2013. The municipality failed to ensure that the graves were properly marked and that the numbers were affixed to the graves as required in terms of the provisions of the Salt Lake Municipality Cemeteries Bylaw number 2 of 2006. The municipality's failure to rectify the wrongful burial of Mr. Khumalo in the grave of the late father of Ms. Siapamuri since 2013 was in violation of Section 4, Section 5, Subsection 1, and Subsection 2 of the Salt Lake Municipality Cemeteries Bylaw of 2006, and Item 2 of the Code of Conduct of Municipal Staff Members as set out in Schedule 2 of the Local Government Municipal Systems Act of 2000. It also prejudiced Ms. Siapamuri and her family as they had to bear the trauma caused by the wrongful burial and will also have to go through the ordeal of exhumation and reburial. The municipality's conduct accordingly constitutes improper conduct as envisaged by the Constitution and maladministration in terms of the Public Protector Act. The municipal manager conceded in his response to the Section 79 notice that the municipality was at fault and indicated that the municipality was in the process of improving the registry system of the cemeteries. He further indicated that the municipality is committed in resolving the matter. Officials of the municipality will be meeting with the families involved to endeavor to find an amicable solution, failing which the municipality will obtain a court order for the exhumation and reburial of Mr. Khumalo and will make a financial contribution in this regard. To remedy this improper conduct and maladministration, we direct the municipal manager to, after consultation with the families involved, approach the relevant sphere of government or approach the Magistrates Court in terms of Section 26, Subsection 1A and B of the National Health Act regulations relating to the management of human remains, 2013 in Section 16, Subsection 8 of the Salt Lake Municipality Cemeteries Bylaw of 2006, in order to obtain an exhumation order that will enable the municipality to exhume the body of Mr. Khumalo that was wrongfully buried in the grave of the late father of the complainant within 60 days from the date of this report and for it to be reburied. To ensure that once the court order is granted, make a financial contribution to the family concerned for the cost of the exhumation and reburial within 60 days from the date of this report. Take appropriate steps in respect of disciplinary action against the officials of the municipality who contributed to the undue delay in the rectification of the wrongful burial of Mr. Khumalo in the grave of the late father of the complainant in terms of the consequence management policy within 60 days from the date of this report. embark on auditing all existing graves to ensure correct marking before loading the information on a newly developed digitized GPRS system in preempting wrongful burials in wrong graves within 16 days from the date of this report. Take the appropriate step to expedite the finalization of the Salt Lake Municipal Cemeteries policy to regulate the management of cemeteries and the threshold capped costs paid by the municipality for the performance of rituals during exhumation of remains of people, and to provide training to the relevant officials that will have to implement the policy within 60 days from the date of this report. Ensure that the audit committee of the municipality reports regularly to the municipal council on the audit outcomes relating to internal audit plan, which includes the digitized GPRS system within 60 days from the date of this report. Establish internal complaint mechanism which will address service delivery complaints raised by the community served by the municipality within 60 days from the date of this report, and to report to council on the implementation of the remedial action taken in paragraphs 1 to 7 above within 90 days from the date of the report, and to provide the public protector with a copy thereof. I shall move over to the report of law versus the Salt Lake local municipality. We investigated allegations of improper conduct and maladministration relating to the wrongful burial of the late Ms. Mkhwebane Mkhwebane in the grave of the late brother of Mr. Isaac Raymond Lowe by the Salt Lake municipality in November 2019. Mr. Lowe lodged the complaint on the 15th of January 2020. He alleged that on November 2019, the municipality removed the tombstone on the grave of his late brother, Mr. Richard Paul Lowe, and buried Ms. Mkhwebane Mkhwebane on top of his brother's late remains at the West End Cemetery in Kimberley without the permission of the family. He further alleged that after he established during his visit to the cemetery that the grave of his brother, Mr. Richard Lowe, had been tampered with, the matter was reported to Mr. Dr. Litibejane, the cemetery manager of the municipality. Mr. Litibejane promised that the problem would be rectified as soon as possible, but nothing happened, despite the Lowe family making several inquiries to the municipality. Essentially, Mr. Lowe's complaint is that the municipality caused the wrongful burial of Ms. Mkhwebane in the grave of his late brother at the West End Cemetery, and that the conduct of the municipality was improper, constitutes maladministration, and prejudiced his family. Having studied the complaint, we focused the investigation on whether the municipality wrongfully buried Ms. Mkhwebane in the grave of the late brother of Mr. Lowe in 2019. If so, whether the conduct of the municipality was improper, constitutes maladministration, and prejudiced his family. We found that indeed the municipality wrongfully buried Ms. Mkhwebane in the grave of the late brother of Mr. Lowe in 2019. The municipality failed to ensure that the graves were properly marked, and number was affixed to the grave, and the register of graves properly managed as required by the Salt Lake Municipality Cemeteries bylaw of 2006. The municipality's failure to rectify the wrongful burial of Ms. Mkhwebane in the grave of the late brother of Mr. Lowe since 2019 was in violation of sections 4, section 5, subsection 1, and subsection 2 of the conduct of the Salt Lake Municipal Cemeteries bylaw of 2006 and item 2 of the Code of Conduct of the Municipal Staff Members as set out in Schedule 2 of the Municipal Systems Act. It also prejudiced Mr. Lowe and his family, as they had to bear the trauma caused by the wrongful burial and will also have to go through the ordeal of exhumation and reburial. The municipality's conduct accordingly constitutes improper conduct as envisaged by the Constitution and maladministration in terms of the Public Protector Act. To remedy this improper conduct and maladministration, the municipal manager must, after consultation with the families involved, approach the relevant sphere of government or approach the Magistrates Court in terms of Section 26, subsection 1A and B of the National Health Act regulations relating to the management of human remains, 2013, Section 16, subsection 8 of the bylaw, and in order to obtain an exhumation order that will enable the municipality to exhume the body of Ms. Mkhwebane that was wrongfully buried in the grave of Mr. Lowe's late brother within 16 working days of the date of this report. Ensure that once the court order is granted, make a financial contribution to the family concerned for the cost of the exhumation and reburial within 60 working days from the date of this report. Ensure that the tombstone that was removed from Mr. Lowe's grave is returned to its original position within 90 working days from the date of this report. Take the appropriate steps in respect of disciplinary action against the officials of the municipality who contributed to the undue delay in the rectification of the wrongful burial of Ms. Mkhwebane in the grave of Mr. Lowe's late brother in terms of the municipality's Consequence Management Act within 60 days from the date of this report. Embark on the audit of all existing graves to ensure correct marking before loading the information on a newly developed digitized GPRS system in preempting wrongful burials in wrong graves within 60 working days from the date of this report. Take the appropriate steps to expedite the finalization of the Salt Blakey Municipal Cemeteries policy to regulate the management of the cemeteries and the threshold cap costs paid by the municipality for the performance of rituals during exhumation of remains of people, and to provide training to the relevant officials that will have to implement the policy within 60 working days from the date of this report. Ensure that the audit committee of the municipality reports regularly to the municipal council on the audit outcomes relating to the internal audit plan, which includes the digitized GPRS system, within 60 days from the date of this report. Establish internal complaint mechanism which will address service delivery complaints raised by the community served by the municipality within 60 working days from the date of this report, and to report to the council on the implementation of the remedial action taken in paragraphs 1 to 8 above within 90 working days from the date of this report, and provide the public protector with a copy thereof. In the matter of undue delay as well, Adams versus Salt Blakey Local Municipality, we investigated allegations of improper conduct and maladministration relating to undue delay by the Salt Blakey Local Municipality in the Northern Cape to finalize a claim for damages to a property situated at 53 Gladstone Street in Kimberley in February 2015. We investigated a complaint was lodged on 24 April 2017 by Mr. Isaac Adams. Mr. Adams alleged that on 9 January 2015, there was a water pipe burst at Gladstone Street, causing his property to be flooded and resulting in extensive damage to his property, including belongings to the estimated amount of 31,000 rand. He lodged a claim for damages with the municipality on the 2nd of February 2015, but was never paid. In essence, his complaint is that of an alleged undue delay on the part of the municipality to finalize his claim for damages to his property, and that this was improper, constituted maladministration, and prejudiced him. We focused the investigation on whether the municipality unduly delayed to finalize a claim for damages to property situated at 53 Gladstone Street in Kimberley in February 2015, and if so, whether the conduct of the municipality was improper, constitutes maladministration, and prejudiced Mr. Adams. We found that indeed the municipality unduly delayed to finalize Mr. Adams' claim. This failure was not in accordance with the relevant provisions of the Local Government Municipal Finance Management Act relating to the managing of liabilities of the municipality and Item 2 of the Code of Conduct of Municipal Staff Members as set out in Schedule 2 of the Local Government Municipal Systems Act 2000. The conduct of the municipality accordingly constitutes improper conduct as envisaged in the Constitution and maladministration and undue delay in terms of the Public Protector Act To remedy this improper conduct and maladministration, the municipal manager must take the appropriate steps to engage with Mr. Adams to offer a settlement relative to his claim for damages against the municipality within 30 working days from the date of this report. To take steps in respect of disciplinary action against any of the officials of the municipality who contributed to the undue delay in the finalization of Mr. Adams' claim for damages in terms of the consequence management policy within 60 working days from the date of this report. Ensure that all officials of the municipality that deal with claims for damages against the municipality are trained in the loss control and insurance policy and how it should be managed within 60 days from the date of this report. Develop an insurance management policy for the municipality in line with loss control and insurance policy in conjunction with Section 61, Section 62, subsection C, and Section 78 of the MFMA to regulate insurance by the municipality against claims for damages and liabilities and submit it to the council for consideration, and adopt within 90 working days from the date of this report. Establish the internal complaints mechanism to ensure that complaints against the delivery of services are expeditiously resolved as per the resolution taken by the high-level meeting between the Public Protector South Africa and the Northern Cape Premier's Governance Committee. Ensure that the Audit Committee regularly reports to the Council on the adopted audit plan and report to the Council on the progress made with the implementation of the remedial action taken in paragraphs 1 to 6 above within 120 working days from the date of this report, and submit a copy thereof to the Public Protector. Further, there is the matter of Havenga. Reports on an investigation into allegations of improper conduct and maladministration relating to undue delay by the Salt Lake municipality to finalize a claim for damages to property situated at 14 West Circular Avenue, West End in Kimberley in February 2015. The complaint was lodged on the 4th of July 2017 by Mr. J. Havenga, the complainant, at the Northern Cape Provincial Office of the Public Protector. The complainant alleged that on the 24th of February 2015, there was flooding in the area of his residence. The water could not be drained through the municipal drainage system because it was blocked. His yard was flooded and the water caused damage to his house and property. In essence, the complainant alleged that undue delay by Salt Lake municipality to finalize his claim of approximately 128,000 rands for damages to his property situated at 14 West Circular Avenue, West End in Kimberley on the 24th of February 2015. Based on the analysis of the complaint, the issues that were identified were where there was undue delay by Salt Lake municipality to finalize a claim by the complainant for damages to his property situated at the address mentioned above, and if so, whether the conduct of the municipality was improper and constitutes maladministration. Having considered the evidence and information obtained during the investigation, the following was decided: that the municipality's conduct accordingly constitutes improper conduct as envisaged in Section 182, subsection 1 of the Constitution, and maladministration and undue delay in terms of Section 6, subsection 4A of the Public Protector Act. The appropriate remedial action was as follows: that the municipal manager of the municipality must take the appropriate steps to engage with the complainant to offer a settlement relative to his claim for damages against the municipality within 30 days from the date of this report. Take the appropriate steps in respect of disciplinary action in line with consequence management policy of the municipality against any officials of the municipality who contributed to the undue delay in the finalization of the complainant's claim for damages within 60 working days from the date of this report. Apologize in writing to the complainant for the delay in finalizing his claim for damages within 30 days from the date of this report. Ensure that all officials of the municipality that deal with claims of damages against the municipality are trained on loss control and insurance policy and on how it should be managed within 60 working days from the date of this report. Develop an insurance management policy for the municipality in line with the loss control and insurance policy in conjunction with Section 61, Section 62, subsection C, and Section 78 of the MFMA to regularize insurance by the municipality's claims for damages.
Right, so we come out of the Public Protector investigation reports briefing. That's all from the On Point team. SA Today will have more news for you at the top of the hour. Have a pleasant afternoon.